Here's a clear breakdown of disputes over flood insurance and buyer cancellations, along with how earnest money disputes are typically handled in Arizona real estate transactions. Disputes over flood insurance and buyer cancellations. Flood insurance. Surprise can trigger cancellation. If a buyer learns mid-transaction that flood insurance is required, e.g., due to FEMA zone designation or lender notification, they may decide the added cost or risk is unacceptable and want to back out. Example: buyer discovers the home is in Zone AE, triggering a $12,500 flood insurance premium they weren't budgeting for. Can the buyer cancel the contract? If the seller failed to disclose the flood zone or prior flooding, a material fact, the buyer may cancel based on misrepresentation or non-disclosure, especially if it's within the inspection disclosure period. If disclosures were accurate and timely, but the buyer simply didn't do due diligence or change their mind, cancellation rights may be limited unless allowed under the inspection or financing contingencies. Earnest money disputes. If the buyer cancels properly within the contract terms, like the inspection period or due to non-disclosure, they are entitled to a full refund of their earnest money. If the buyer cancels outside of allowable terms, the seller may claim the earnest money as liquidated damages. Disputes over who keeps the earnest money typically go to mediation or interpleader, where escrow holds funds until the parties or court resolves the issue. Here's how earnest money disputes are typically handled in Arizona when a buyer cancels a real estate contract. How earnest money disputes are handled in Arizona. 1. It depends on the timing and reason for cancellation. If the buyer cancels within a valid contingency, inspection period, loan denial, title issue, etc., they're usually entitled to a full refund of the earnest money. If the buyer cancels outside of those contingencies or for a reason not permitted by the contract, the seller may claim the earnest money as liquidated damages. 2. The escrow company won't decide escrow holders, like title companies, can't release earnest money without written agreement from both parties or a court order. If the parties disagree, the escrow company will hold the funds and may eventually file an interpleader action, a court process asking a judge to decide who gets the money. 3. Dispute resolution process, under AAR contract. Most Arizona residential transactions use the AAR Residential Resale Real Estate Purchase Contract, which includes mediation. First, parties must attempt to resolve the dispute through mediation before filing a lawsuit. Then, arbitration or litigation. If mediation fails, the parties can pursue arbitration or go to court, depending on what they agreed to in the contract. Attorney fees and costs may be awarded to the prevailing party if the dispute goes to litigation or arbitration. In Arizona real estate, if there's a dispute between a buyer and seller, especially over something like earnest money, and they use the standard AAR Residential Resale Real Estate Purchase Contract, mediation is the first step in resolving the issue before going to court or arbitration. Here are the typical steps in the mediation process. Steps in mediation for buyer-seller disputes. Arizona real estate. 1. One party initiates mediation, either the buyer or the seller sends a written request for mediation to the other party. The AAR contract requires the parties to attempt mediation in good faith before litigation or arbitration. 2. Select a mediator and schedule both parties agree on a neutral third-party mediator, usually someone experienced in real estate disputes. The mediator must be mutually acceptable, or the parties may use a list from a service provider like the Arizona Association of Realtors, Dispute Resolution Program. 3. Pre-mediation preparation. Both parties may be asked to submit a summary of the dispute. Relevant documents, e.g., contract, cancellation notice, inspection reports, and any offers or attempts to resolve it informally. 4. Mediation session. The parties and their representatives, if any, Meet with the mediator. O. The mediator facilitates discussion, but does not make a decision. They guide both sides toward a mutual agreement. O sessions are usually confidential and non-binding, unless an agreement is reached. 5. Settlement agreement, if reached. O. If the parties agree, the mediator or attorneys draft a written settlement agreement. O. Once signed, it becomes a binding contract, enforceable in court. 6. If no agreement is reached. O. If mediation fails, the parties may then proceed to arbitration, if agreed to in the contract, or file a lawsuit in court. Quick notes. Mediation is quicker and cheaper than court and often preserves relationships. If either party refuses to mediate, they may weaken their legal standing later if they go to court. Time is of the essence. Delays in initiating mediation could stall the entire escrow or post-cancellation process. What is arbitration in real estate? Arbitration is a legal process used to resolve disputes outside of court, where a neutral third party, the arbitrator, hears both sides and then makes a binding decision, kind of like a private judge. In Arizona real estate, arbitration is sometimes required if it's written into the contract, like the AAR residential resale purchase contract offers it as an option. Common reasons for arbitration in real estate: earnest money disputes, breach of contract, e.g., a buyer backing out or a seller refusing to close, disputes over undisclosed defects or flood zone issues, disagreements over repair obligations or timelines. How arbitration works, step by step. 1. Agreement to arbitrate. Both parties must have agreed in writing, usually in the purchase contract, to use arbitration instead of court. 2. Selecting an arbitrator. Both parties agree on a neutral arbitrator or panel. Arbitrators are often attorneys, retired judges, or trained professionals. 3. Presenting evidence. Each side presents their evidence, documents, and witnesses. This is more informal than a courtroom, fewer rules and faster timeline. 4. Arbitrator's decision. The arbitrator reviews the case and makes a decision. This is usually final and binding, meaning it can't be appealed with very limited exceptions. 5. Enforcing the decision of the winning party can have the arbitration award entered in court as a judgment to enforce payment or action if needed. Key differences: arbitration versus mediation. Mediation. Arbitration, facilitated negotiation. Binding decision. Mediator helps parties agree. Arbitrator decides the outcome. Non-binding, unless signed agreement. Legally binding, confidential. Also private, confidential, low cost. Collaborative, faster than court, but more formal than mediation. Let me know if you'd like a visual comparison chart or a version for client handouts. Verma v. Stour, Arizona Court of Appeals, 2009. In this case, the buyers, the Vermas, entered into purchase agreements for properties that were subject to federal flood easements, which prohibited construction for human habitation. The purchase agreements explicitly stated that the properties were in a floodplain or within flood easements. The Vermas received title commitments indicating the flood easements, but did not object within the specified time frame. Later, they sought to rescind the transactions based on Arizona revised statutes, Paragraph 33-422, arguing that the sellers failed to disclose material facts. The court ruled in favor of the Vermas, allowing them to rescind the contracts and recover their deposits. Justia law plus one co-counsel plus one co-counsel plus one, Justia law plus one. Morgan v. Adams, California Court of Appeal, 2005. In this case, the sellers disclosed prior flooding incidents caused by a sewer drain backup during heavy storms. They completed a property condition disclosure form and discussed the flooding history with the buyer, including showing areas prone to flooding. After the transaction closed, the buyer discovered a videotape of a prior flooding incident and sued the sellers and their agent for misrepresentation and concealment. The court found that the sellers had adequately disclosed the flooding history and ruled in their favor. National Association of Realtors. Potter v. First Real Estate Co., Alabama Supreme Court, 2003. The buyers purchased a property and later discovered it was located in a floodplain, requiring them to purchase flood insurance. They claimed that the seller and real estate company failed to disclose this material fact. After the property experienced flooding, the buyers sued for misrepresentation. The court found that the buyers had received a survey indicating the floodplain status before closing and ruled in favor of the defendants. Co-counsel. The key takeaways. Disclosure obligations. Sellers are generally required to disclose known material facts, including flood risks and history, to prospective buyers. Buyers' due diligence. Buyers should thoroughly review all provided documents, such as surveys and title commitments, and conduct independent investigations to identify potential flood risks. Contractual rights. Purchase agreements often contain specific provisions regarding disclosures and the buyer's right to cancel the contract based on undisclosed material facts. If you're involved in a real estate transaction and have concerns about flood risks or insurance requirements, it's advisable to consult with a real estate attorney to understand your rights and obligations fully. Arizona Revised Statutes. ARS. Paragraph 33-422. Pertains to sellers' disclosure obligations in real estate transactions, particularly focusing on the need for sellers to disclose material facts about the property's condition that may affect the buyer's decision to purchase. Here's a breakdown of ARS. Paragraph 33-422. 1. Duty to disclose material facts. Under this statute, sellers are required to disclose material facts that could influence the buyer's decision to purchase or affect the property's value. These disclosures are typically made via the Seller Property Disclosure Statement, SPDS, a document that must be completed by the seller and provided to the buyer. 2. Material facts. Defined. Material facts include any information that might reasonably affect a buyer's decision to buy a property. This could include known defects or damages to the property, information about the property being in a flood zone or floodplain, any zoning issues, legal encumbrances, or easements that affect the property, any history of structural damage or major repairs, any other issue that could affect the desirability or value of the property. 3. Specific requirements for disclosures. If a seller knows of any conditions such as previous water damage, flooding, or drainage issues that could affect the property's value or the buyer's use of the property, they must disclose this information. The law applies to residential real estate transactions and requires the full disclosure of known issues, even if no formal complaint or legal action has been taken, e.g., flood insurance claims. 4. Consequences for non-disclosure. If a seller fails to disclose material facts, they can be held liable for misrepresentation or fraud. The buyer could potentially seek a remedy under contract law, including canceling the contract or seeking damages if the failure to disclose leads to harm or an increase in costs. The statute of limitations for bringing a claim for non-disclosure or misrepresentation in Arizona is typically 2 years from the date of the transaction. 5. Impact on buyer. For buyers, failure to disclose material facts can give the buyer legal grounds to cancel the sale or sue for damages. A buyer might also have the option to seek rescission of the contract if they can prove that they would not have purchased the property had they known about the undisclosed issues. Example: if a seller knows that a property is located in a floodplain or flood zone and has experienced flooding in the past, even if no insurance claim was filed, they must disclose this information in the SPDS. If they fail to disclose this information, and the buyer later discovers the property's flood risk, the buyer might have the right to cancel the transaction or seek damages. Conclusion. ARS, paragraph 33, 422, reinforces the importance of full and honest disclosure in real estate transactions. Sellers in Arizona are legally obligated to disclose any material facts about the property that may affect the buyer's decision to purchase, including the potential risk of flooding. Failing to do so can lead to significant legal and financial consequences for the seller. This statute is part of the broader legal framework designed to protect both buyers and sellers by ensuring transparency and fairness in real estate transactions. Mitigation strategies for real estate agents and buyers in situations involving potential flood issues can help minimize risk, reduce liability, and facilitate smoother transactions. Here are some key strategies. Mitigation strategies for real estate agents. 1. Ensure full disclosure. Encourage sellers to disclose all material facts related to flood risk, history, and insurance issues via the Seller Property Disclosure Statement, SPDS. This includes flood zone designations, past flooding incidents, drainage problems, and any flood insurance claims. Verify flood zone status using FEMA maps or other tools to ensure the information provided is accurate and up to date. 2. Educate buyers about flood risk. Proactively discuss flood risk with buyers, especially if the property is in a designated flood zone. Explain how flood insurance might be required or could affect the property's value and insurability. Provide resources for understanding flood risks, such as local floodplain maps, historical flooding data, and contact information for insurance agents who specialize in flood coverage. 3. Provide a clear understanding of flood insurance. Help buyers understand the implications of flood insurance on the property. Discuss whether flood insurance is required by the lender, how much it might cost, and the specific coverage options available. Ensure buyers are aware of the National Flood Insurance Program, NFIP, and how to obtain flood insurance, especially for homes in high-risk flood zones. 4. Advising on inspections and due diligence. Encourage buyers to conduct thorough inspections during the due diligence period, focusing on water damage, drainage systems, and flood-proofing features of the home. Consider advising flood zone determinations, as some properties may have been rezoned or have updated FEMA flood maps that could impact flood insurance requirements. 5. Set clear expectations for contingencies. Recommend including flood-related contingencies in the purchase contract. For example, buyers could include clauses that allow them to cancel the contract or renegotiate the price if flood insurance premiums are higher than expected, or the home is found to be in a high-risk flood zone. Mitigation strategies for buyers. 1. Conduct due diligence. Obtain a flood zone determination and consult FEMA flood maps to verify whether the property is in a floodplain or high-risk flood zone. Ensure the home is not in a flood-prone area or that flood history hasn't been hidden. Check historical flood records by asking the seller for any past flood incidents and reviewing public records related to flooding in the area. The goal is to get a comprehensive understanding of the flood risk. 2. Seek professional flood assessments. Consider hiring a flood risk assessor or professional engineer to evaluate the property's flood history, drainage systems, and vulnerability. This is especially important if the buyer is uncertain about the property's susceptibility to flooding or water damage. Use flood elevation certificates if the property is in a flood zone. These certificates provide information about how high the property is relative to the base flood elevation, BFE, which affects flood insurance premiums. 3. Understand flood insurance costs. Factor flood insurance premiums into the budget. Before moving forward with the purchase, understand how much flood insurance will cost and whether the property qualifies for flood insurance under the National Flood Insurance Program, NFIP. Consult with flood insurance providers early in the process to get quotes and understand the potential cost impact. Be aware that flood insurance premiums can be high, particularly for properties in flood zones. 4. Know the buyer's rights. Understand cancellation rights under the purchase agreement. If flood insurance is deemed too costly, or if the property has a significant flood risk, buyers may have the right to cancel the transaction under certain contingencies. Review the contract carefully to ensure that flood-related contingencies, such as insurance requirements or flood zone designation, are included, and that the buyer has the right to cancel if these issues are not acceptable. 5. Investigate property modifications and mitigation measures. Assess flood mitigation measures that may already be in place on the property. For example, check for raised foundations, flood barriers, sump pumps, or landscape grading that directs water away from the home. These can reduce flood risk and insurance costs. Research the potential for additional mitigation if the home is located in a flood zone but doesn't have flood mitigation features. Buyers can negotiate for these features to be included as part of the sale or explore the cost of retrofitting the property. General mitigation strategies for both agents and buyers. 1. Use clear communication. Maintain open, honest communication between all parties, including the seller, buyer, agents, and insurers. Ensure that everyone understands the flood risk, mitigation measures, and financial implications of flood insurance. 2. Negotiate terms in good faith. Both buyers and sellers should negotiate terms fairly and in good faith. If flood-related concerns arise, negotiate for reasonable solutions such as price reductions, flood insurance adjustments, or home repairs prior to closing. 3. Consider flood zone map updates. Stay informed about recent flood zone map updates from FEMA or local authorities. New flood maps can reclassify properties from low-risk to high-risk zones, affecting flood insurance requirements. Buyers and sellers should be aware of any changes in the flood zone status during the transaction process. By utilizing these strategies, agents and buyers can reduce their exposure to risks associated with flooding and ensure that they are making well-informed decisions during real estate transactions in flood-prone areas. If a property is not located in a designated flood zone, according to FEMA flood maps, but the grading or landscape features of the property lead to flooding during heavy rain, there are several potential consequences and actions to take. These situations may not be covered by typical flood insurance, but they can still create significant challenges for both buyers and sellers. 1. Disclosure obligations for sellers. Even if the property is not in a FEMA-designated flood zone, the seller is still required to disclose any material facts that could affect the property's value, safety, or functionality. This includes issues like poor grading or drainage problems that cause water to pool on the property or damage the structure. Seller's duty to disclose. Under Arizona law and in many other states, the seller must disclose any known material defects, including grading issues that cause flooding or water intrusion. If the seller is aware of the grading issue, it must be included in the Seller Property Disclosure Statement, SPDS. Example: if the grading in the backyard of the property causes water to pool against the foundation, potentially leading to mold or structural damage, the seller must disclose this issue to the buyer. 2. Inspection and due diligence by the buyer. Buyers have the right to investigate and assess the property during the due diligence period. If there are grading or drainage issues that lead to flooding, the buyer should take the following steps. Hire a professional inspector. It's advisable to have a qualified home inspector or civil engineer assess the drainage and grading systems of the property. This expert can identify any areas where water may pool or flow improperly, causing potential damage to the home. Water drainage system. The inspector may assess whether the grading of the property is directing water toward the foundation, or if there are issues with gutters, downspouts, or other drainage systems that need to be corrected. Evaluate potential flooding risks. Even if the property is not in a flood zone, flooding caused by grading issues can lead to damage over time. Buyers may want to evaluate how frequent this flooding is and whether it is causing or could cause significant damage, e.g. to the foundation, basement, or landscaping. 3. Potential consequences for the seller. If the buyer discovers flooding caused by poor grading and it wasn't disclosed by the seller, the buyer could take legal action. The seller could face several consequences. Breach of contract or fraud claims. If the seller intentionally concealed or failed to disclose grading issues that lead to flooding, the buyer may have grounds for legal action under the theory of fraud or misrepresentation. Cost of repairs. If the buyer discovers the grading issues during the inspection period, they may request the seller to fix the issue before closing, or they could negotiate a price reduction to account for the cost of correcting the grading problem. Cancellation of the contract. If the flooding issue is significant, the buyer may choose to cancel the contract, especially if the flooding causes substantial damage or will require costly repairs. Depending on the terms of the contract, the buyer may be entitled to recover their earnest money deposit if they cancel the contract due to undisclosed material defects. 4. Mitigation for buyers and sellers. Both parties may take steps to resolve the situation. For sellers, correct the grading issue. The seller may choose to correct the grading problem before the buyer inspects the property, thus reducing the likelihood of the buyer discovering the issue during the inspection period. This may include installing proper drainage systems, regrading the yard, or adding landscaping features to redirect water. Offer price. Reduction or repair credits. If the grading issue is discovered too late for the seller to fix before closing, they may agree to lower the purchase price or offer repair credits for the buyer to address the issue after closing. For buyers, negotiate for repairs. If grading issues are discovered during the inspection period, the buyer can ask the seller to make repairs before closing. Alternatively, the buyer may negotiate a price reduction to offset the cost of correcting the grading or installing proper drainage. Require a warranty or guarantee. Buyers may request that the seller provide a warranty for the repair work to ensure that future flooding issues are addressed and do not reoccur. 5. Potential legal issues and remedies. If the flooding issue becomes a long-term problem and is not properly disclosed, legal action could be taken after closing. Water damage claims. If water damage occurs as a result of improper grading and it wasn't disclosed, the buyer may be able to file a claim for damages against the seller, especially if they can prove the seller knew about the issue and intentionally concealed it. Insurance issues. While flooding due to grading problems is typically not covered under standard flood insurance policies, it could be covered under other homeowners' insurance policies if the damage is classified as water intrusion or foundation damage caused by improper grading. 6. Insurance considerations. Homeowners, insurance coverage. Depending on the nature of the flooding and the policy, homeowners' insurance may cover some types of water damage. However, this is typically limited to damage caused by specific circumstances, e.g., burst pipes, and may not cover flooding caused by grading or drainage issues. Flood insurance. If the buyer is concerned about the potential for flooding due to grading issues, they may consider purchasing flood insurance, even if the property is not in a FEMA-designated flood zone. However, flood insurance typically covers flooding from external sources, such as rivers or heavy rains, rather than issues caused by poor grading on the property itself. Conclusion. If a property is not in a flood zone but grading issues cause flooding, the seller is still required to disclose these issues to the buyer. Both parties have the opportunity to address the issue during the transaction process through negotiations, repairs, or price adjustments. Buyers should conduct thorough due diligence, including inspections, and sellers should ensure full disclosure to avoid legal disputes.